Oh, Shannon tonight? Our new employee in the planning department.
She's planning, building and assessing and conservation stuff, so.
I want to meet her.
Right.
I'll have to come in and meet her.
Right, we're live, we're recording.
All right, I'm gonna bring the meeting to order. I'm Don Berube, 135 River Road.
Mike Wayne, select board rep.
Carrie Mackinnon, Community Development Director.
Adam Sandall, 9 Edward Drive.
Kim McDaniel, 117 Page Road.
Michael Lawton, 3 Asa Drive.
Jonathan Petrangelo, 5 Whittier Drive.
Sandy Crystal, 1 Shoreview Drive.
All right, we got no conceptuals or minor modifications, so we're gonna go right to public hearings. Which first up is application 203-23, 12 Tallwood LLC. Final approval of change of use site plan application, manufacturing facility, which with associated site improvements in the general industrial zone located at 12 Tallwood Drive. And I am going to be recusing myself for this and pass it over to Sandy.
Andy, do you want me to give the little update of why we're back?
Sure, yes, thank you.
Sure. So this site plan application was conditionally approved at the previous meeting. At that time, it was believed that the amount of traffic triggered by this development would not require a traffic impact assessment. And since that time, it's been determined that it actually did. So they've prepared that assessment, and we wanted to hold a public hearing so that the board and the public were able to have access to that information before the final plans were signed.
Good evening. My name is Matt Peterson with Peach Nordstrom Associates here. Saying proposed change of use in Friday 12 Tallwood. As was just stated, we were in front of the board on May 18th. We received the notice of decision. There were 9 conditions on that. One of them was that we provide evidence that we do not need a traffic study. Since that hearing, we requested, since I stated at that hearing that we requested that we be allowed to do manufacturing in all 3 buildings, even though currently we're only looking to do one of the buildings, the center buildings, as I said, at that hearing for actual production and the other 2 for storage. This one would be where the raw materials come in, it gets made, finished products here, and it goes out. Even though we said that, we did this as the business grows, he wouldn't have to come back for a change of use every time if he expands into the next side or to the next building. We thought it made sense at the time. So we then went back, we looked at the traffic numbers for all 3 buildings. We found out that the IT manual says that all 3 buildings is manufacturing and it generate 334.25 trips. Anything over 200 trips triggers the traffic analysis. Just so that you guys understand, I wasn't kind of trying to circumvent things last time. 2 buildings would be 222 trips. 1 building would be 111 trips. So again, it kind of wouldn't have triggered if we were at that point. The client at the last hearing, we have 6 basically tractor trailer. On a good day, that average 2 each, that's 24 trips. We currently have 50 employees. That'd be 100 trips. We're looking at about 124 trips for the facility right now as it's operating, as he wants to open up and operate. So again, in conclusion, I feel the pros of change of use will have less impact than the current facility. I did take a look at like Saturday numbers, and those trips are about 1,600 for the soccer field, but there's not a lot of studies here and there on it, so I didn't really kind of want to put that in there. But we believe that this is a good spot for this change of use. It makes sense, and the traffic is what we presented the last hearing. But again, it's full build out as this goes, maybe 5 years or so, it was going to generate a little bit more. So that's it. I can answer any questions or comments.
Any questions? Okay, I guess we'll open the public hearing now. Anybody have any questions or concerns? All right, I will close the public hearing. So I guess we need to vote to approve.
For final approval.
For final approval, and I believe that they addressed all the other points. Right,
Yeah, so typically after the application is conditionally approved, staff works with the applicant to make sure all the conditions are met, chair signs the plans, but since this one had a little bit of a, we wanted to make sure you had a chance to review this, so that's why it's coming here for the public hearing for your final approval, and then Sandy will sign the plans afterwards.
I want to make a motion.
That's a little unusual, right? Because. when you get-
Yeah, and but in your regulations it says that they can only be approved without a public hearing if it's kind of administrative conditions or things without like judgment having to be made. And I felt that there was some, Sandy and I both felt that there was some judgment being made here. So that's why it's here.
You could also vote to remove the condition that was the one for the traffic study.
Either way.
Oh, okay.
That what was submitted suffices and that's no longer required as a condition.
Yeah, can we just do that?
Yeah, I'm sure that works too, as long as you're comfortable with that.
Sure. So. What's the motion?
So it's. Myself here, so it's already conditionally approved. So we're just removing a condition.
Condition number 7.
Yes, I do have the number. There you go.
You have it there.
It's kind of just their response to it, but
I'll make a motion that we remove condition number 7 regarding the requirement for traffic study for application number 203-23 as that traffic study has been submitted.
Second.
John. All those in favor?
Aye.
Any opposed? Right, great.
Thank you very much.
Thank you.
Have a good night.
Thank you.
Okay. I'm actually gonna take this a little bit out of order. Because the next 2 applicants are gonna take quite a time and hopefully the one that doesn't have a CUP. Could be hopefully shorter. So we're gonna application 407-23. Andrew Matthias. Matisse.
Thank you for considering rearranging the order.
All right, so I'm Andrew Matisse, 1 Beaverbrook Drive. My application was for, in addition to the sugar house I had built. There was a CUP I had filed a couple, like 3 years ago to build the sugar house. And in that plan, there was a plan to build an addition. I have not built the addition, but I plan to modify the design a little bit. So I had submitted an application for that addition. And I was notified that I may not have to file it because of statutory rights regarding agricultural use. So I believe Carrie has more information.
I need to kind of lay out. So the table of uses for the Wetland Conservation District, which is in your packet in the zoning ordinance, shows agricultural use as being permitted within the wetland buffer. And then it footnote number 1 says that it includes agricultural activities as defined in RSA 21:34A. But also included a section from which includes structures used in the production of maple syrup. So based on that information, it was my opinion that the CUP is not necessary or not required for a building, a structure being used for maple sugaring within the wetland buffer. In addition, when Mr. Matisse applied for his CUP in 2020, there was some confusion or an error about what zoning district he's actually in, which has since been corrected. I found documentation of that. It was previously listed that he was in the residential district, which does not allow agriculture. He is now correctly listed as the rural district, which does permit agriculture. So all those pieces kind of connect. And I consulted with Matt Monahan from Central New Hampshire Regional Planning Commission. And he felt the best thing to do was to bring this all to you folks. This is your ordinance, your regulations to interpret, and just see if you agree with my interpretation of this.
I do have a copy. I pulled out all the RSAs too, if there's any question outline of everything that you need to reference it.
I also, there was some question because maple sugaring is a short season by its nature. So there'd be other personal uses in the structure in the off season. But the definition of agriculture also includes the residence or residences of owners, occupants, or employees. So it includes structures used for personal use associated with the agricultural use anyway. So I still feel that he doesn't require CUP.
Okay, because it's agricultural and is it permitted in the rural district?
Yeah.
So does he just withdraw his application?
That would be my recommendation, as long as that's, I just wanted to make sure you all agree.
That's what it says. That's what it
I
says.
mean, that, yeah.
Yeah.
And as far as doing his addition.
You'd be working with the building inspector on.
Yep, absolutely.
The only other thing I'll mention is that it also says that provide the agricultural activities, provided that such activities and operations are in conformance with 482A and the most recent best management practices. I don't know how we confirm that his practices are in conformance with best management practices, but
I'm not sure the best management practices address buildings, actually. Because I think they're geared more toward erosion and nutrients and.
I mean, you're making maple syrup, right? Yeah.
Yep.
Capping trees and.
Yep.
So, I mean, do we have a vote whether we need something or do we just get a consensus?
I think it's probably a consensus. We can document. And does that meet your needs? I know you were looking for some documentation that went through the correct process.
Yeah, so as long as it's on the record, like that the planning board reviewed that and made a motion accepting it, then at least it would address any clarity, especially as complaints come in, they can just be pointed to this and it's like, no, that's, you know, at least it's covered. And the only thing I would want to leave from this meeting is an understanding as to kind of the scope of that with this, like as far as like my interpretation, like when I have to process wood too, so I split wood out in my backyard. So I just want to in the future be able to point to something, at least to understand, and at least to come to an understanding.
I mean, so the wood you're processing, is that for
It's
your
for
use, you selling? the wood?
my use. I've got a sawmill that I use to mill lumber to build the sugar house, and I'll be using that to build the addition. But the wood I'm talking about has to do with the production. So I've got to burn wood to boil the sap down to syrup. And I do that out in the woods. So I get it off my front yard. With the logs out of my front yard are for the structure, but the stuff I use for burning gets stacked in a wood shed. next to the sugar house. But I do all the splitting, I do all the storage of the logs back there, so I've got like a stockpile that holds me at least for 2 years.
Okay, so I mean, you're having wood,
I do it myself.
you.
Yep.
Is it all coming off the property? I mean, is it?
There's some,
Or is it?
I've got some on the property that's ready to get processed, but a lot of the wood I've gotten is from off the property.
Okay.
Just
Curious on that, not that.
yeah,
The difference in it.
I would end up stripping my land dry if I
Yeah, that's what I mean,
don't mind, yeah,
because it's not that big of a lot, right? What is it?
2.26 acres.
What do you say?
And I like the forested nature of it. I don't want to harvest too much. I'd like to get rid of the pines, but
I do want to mention that as long as the wood storage is out of the wetland, that's fine, but the wood should not be stored in the wetland because that would be considered fill.
In the wetland or the wetland buffer?
In the wetland,
In the wetland,
no, in the
yeah.
wetland, because he has a portion of his property that's what.
yeah, and I'm not disputing that fact. While it's not, my property is not fully delineated. I've done the due diligence, at least this area that I'm processing in is not in the wetlands, just in the buffer. But the processing it's at least within the setback of the stream. So it's the most convenient area. It's the most like least destructive. The most wetted portion of it, I stay out of. But I think it'd be good to maybe get some clarification around that, because my understanding is some of the any practice or activity ancillary or any practice or activity on the farm incident to or ancillary or in conjunction with the farming operations includes but not necessarily restricted to, and it calls out forestry and lumbering in there too as well. So I don't think it would restrict me there.
Well, the cutting is fine. It's the storage of the wood in the wetland.
Okay. It's stored between the sugar house and Beaverbrook Drive, so it's out of that, but the stuff that's not covered is out there, so. I'd rather not process it.
Store wood and wet, right? I mean,
Yeah, it's not gonna be, well, right now, it's not in an area that I want it to be, because the wood's gonna rot if I keep it on the ground.
yeah, that's my point. I like to work.
Well, that's right. Yeah. I mean, it needs to not be in the wetland.
Yeah, I've identified an area way out back that's not in the, in any wetted area. That I do plan on storing it back there and process. So I want to move all that stuff out of there. So the access may be difficult, and I'll adjust that at a later time, but right now I'm pretty much just this addition, and that's what I'm looking at.
Yeah, I do think that it would be to your advantage to have a full delineation done on the lot so that
Mhm.
where the line is and where you can store the wood and not have any potential violation.
Okay,
I think a much better wood to burn if it's not.
yeah, exactly. The other thing, I guess, if it's pertinent, I did pay for the application. I just would talk about a portion of that.
So you have the authority to waive fees, so we did have to put the note, we did put the publish the public hearing notice in the newspaper and notify the abutters. So we have expended those funds. Breakdown. So the fees breakdown is $400 for the application fee and then $20 per abutter. So if you wanted to waive the 400, the 240 would cover the notification fees that the town incurred.
I would, yeah, I mean, we've come this far with it, but it's, yeah, I mean, would you be happy with getting the $400
I'd be happy with that.
back on, not costing the town money.
Yeah.
Yeah, everybody else.
So-
Any other comment on that of? So,
Sounds fair.
and anybody have any comment or thoughts of,
So it sounds like a thing, you don't need the CUP, do we need to have a public hearing?
yeah, I guess that's, I mean, it's been advertised as a public hearing, we probably get some here and.
Just looking at these notes, there's some people who are angry. And just I don't want.
Even if he withdraws his application, there's nothing to talk about.
Okay.
It's not a planning board issue.
Yeah, I agree. So if you. I think it would be helpful if someone would make a motion to explain that. The board feels that a CUP is not required for this purpose, based on the fact that. It's an agricultural use in the wetland buffer.
In a rural area.
Exactly.
So I'm making a motion.
We're gonna require a wetland delineation.
I mean,
No,
how do you?
I think it's suggested,
It's
It's already, it's already been delineated in this area.
right, but the part of the property where you have some of the wood stored may not be delineated.
Yeah,
So it may not be as clear. Where
And this
that,
is Sandy's suggestion.
Right.
To have the whole
Just asking,
property.
yeah,
Right,
just
right.
asking Because she brought it up.
I think if I were to, so I can move all those, I think if I were to come back and if I were to want to build something right there. Well, I guess you're saying it's fill as well, so. I'm not disputing it. Just looking for clarity because I get nervous because everything I do back there, I'm here having to.
Not, I can't make motions, right?
Correct.
I was on fire last time.
I'll make a motion that based off of the information provided in the document referenced, should I reference the full title of that document?
Sure.
The 2022 New Hampshire Revised Statutes, Title I, State and its government, Title 21 Statutory Construction, Section 2134A, Farm and Agricultural Farming, that it would not require a conditional use permit for application 407-23.
I'll second.
All those in favor?
Right.
Opposed? Yeah.
And thank you, I appreciate it. And then the refund,
Do we want a motion for,
Yes, please.
I'll make a motion to refund the amount of $400 for application 407-23.
I'll second.
all those in favor?
Aye.
Opposed?
have a good night.
Thank you.
Just one other thing I'll mention while we're discussing it. I talked about this with Sandy, but in that chart, the wetlands, it's not really about you. It's just about the ordinance. You're fine. On the uses prohibited, permitted, and requiring a conditional use permit in the Wetlands Conservation District. I think we need to revisit that chart. Especially section on top. Yeah, so there's the one that says erection and construction of structures. It says not permitted in any of the districts and any of the wetlands, prime wetlands buffers. And that's really what his request was for a structure in the wetland buffer. And it says that's not even something you can request a conditional. use
And
permit
I
for.
think that we
think it's
permitted
perhaps
sheds in
there.
buffers before, or a part of a garage in a buffer.
So
So,
yes, we need to,
I
so I think we need to revisit the chart.
So we'll add that to the list.
uh. When do we start having 2 meetings a month? Two? Okay, we are moving right along. Application 501-23, Strategic Contracting Company LLC, continued from 6:15 for a major subdivision for 5-lot residential subdivision located at 178 Wood Hill Hooksett Road. I think at the same time, we're going to talk about application 404-23. Strategic Contracting LLC, also continued from 6:15. Wetland protection conditional use permit for 1,835 square feet of buffer impact for a driveway providing access to a single-family house lot located at 178 Wood Hill Hooksett Road.
Evening.
Hello, good evening.
Good evening.
Welcome back.
My name is Pat Panziaco. I'm an attorney for strategic contracting. I'm here tonight with Tim Bernier. We're back again. We were last here on May 18th. At that time, Tim gave you a brief overview of the application in the CUP. You accepted those applications and we had a long talk about 302P, I believe. Yes, section 302P. And that is kind of a threshold issue. And if I recall correctly, you were going to talk to town council to get some guidance on that. Our position was that we did not think it applies to an existing town road. We provided you many plans showing that in some instances it was waived, others it was denied, Mr. Day, and other times it was just ignored, it appears. And we still maintain that when you design a new road with lots on it, that's when you can decide how many lots are on it and the design accommodates for that. But retrospectively, applying it to an existing town road creates a very difficult situation, especially when, as the case is here, you have Wood Hill Hooksett Road going all the way through, but in the middle, it's become class 6 for reasons that I'm sure are sound, but going into class 6 shouldn't automatically designate it a town road and impact private property rights. We had to talk about that.
So the other big piece that we talked about and was, I know my bigger point was the last subdivision. And it was put in that it would not be subdivided again.
Subdivided.
That's
And we did talk about that. And what I had said to you was, and this is my opinion, and it does go back to the prior planner also, I don't think that application was appropriate because it is an existing town road and nothing's changed. It was wrong then, it's wrong now, in my opinion. And although we were invited to reopen the application and revisit it, the application where that note was imposed, but the applicant was unwilling to do that. The other piece of this too, though, if you feel as though it does apply, because a private condition like that is our problem if it clouds the title to our property. There's really no realistic way there will ever be a second access to Wood Hill Hooksett Road, at least not on this end. Tim knows more about the surrounding properties, but we've looked at that and they're either developed or privately owned, or there's wetland there. I mean, Tim, you looked at that, didn't you, in the conservation land in Hooksett? And
Well, you just, nothing's gonna come in from the Hooksett side because that's all conservation land in Hooksett. The likelihood of taking the class 6 section of Wood Hill Hooksett Road, making it class 5, it goes through your town forest now. There's no developable property there. It's, the forest was taken to preserve it as open space for the town, so my feeling is the town's not gonna be particularly thrilled about the idea of opening that back up again as a town road. And that's kind of the end, and then everything else, you know, we did, you know, years ago, there's a road, Rose View goes up behind there. All those lots have now been developed, so that cut off any potential for that. So there's really no place, this road is gonna be forever a dead end, I think.
So in the interest of time,
Mhm.
what's changed since the March 18th meeting?
We
on your
don't,
end?
we have nothing else. You were going to confer with town council and you didn't make a decision. We're asking you about this application. We can't go back and reopen an application we weren't a party to. Mr. Day gave you a sworn affidavit also as to the circumstances of why he agreed to that at the final meeting being shown on the plan. That's our problem to resolve, not this board. This board only has to deal with the application that Tim submitted. We don't feel it applies. Putting the covenant aside, we're going to have to resolve that with the court one way or another. But we would like to, if that's the case and we go to the court, we would like to be able to tell the court what the board thinks. What does the board feel it applies to the current plan, notwithstanding the covenant? That's what we're looking for, is guidance from the board. And I think I heard Carrie say it, it is your regulations and they're yours to interpret. Because the court will ask, well, what does the town think? So no matter how you slice it, whether it doesn't apply or a waiver is required, there is no way we can cure this. It's the last 3 lots that'll probably be developed on that road.
Well, I mean, I'm pretty sure that's what the board thought last time when this lot was divided into.
Well,
It said, we're not gonna divide that any further.
but they
I
don't,
wasn't there then either, but.
right? But guess what? They don't have that authority. They don't have the authority to tell somebody they can't subdivide and reasonably use their land. And honestly, and that's exactly what has happened here inadvertently. I'm not saying they intended to do that, but what it took away the development rights of this property by imposing that covenant. Our problem, not the board's. The application's closed. But as to what's proposed now, if we were to say, put that aside for us to fix, and any decision you make can be subject to us resolving that note issue. What would you do if you could do it over again? I guess is
You're
the
asking
question.
Solve the threshold issue of allowing the road to be grandfathered in on the condition that you sort out this,
Yes,
what you view as an erroneous
we do.
agreement made 20 odd years ago.
Yes, there was a lot of duress at the time for Mr. Day. His mother was in the nursing home. She was very sick. He needed to transfer the lot to pay the nursing home. He put that right in his affidavit and he did that with his attorney. So,
I mean, and they agreed to it. And that was, I mean, he was under, I mean, they needed the money.
he needed the money.
Needed money.
He was desperate.
Sold the land and part of buying the land was.
Paid.
You know, selling the land was agreeing to that.
That's exactly right. So I'm asking you,
So the person that was bailing them out for buying it and didn't, you know, wanted that in there,
Mhm.
well, you know, it didn't, now.
Okay.
Already has, I mean, I'm just trying to look at this from
Mhm.
the different angles of it,
Yep.
you know, who's involved and.
Are you suggesting that this was an idea that was proposed?
But why, you know, where did the. Not allowing it to be subdivided anymore, I mean, was that this pushed by the board or was that also part of the,
Yes,
I mean, did we have
the minutes.
somebody at the meeting here that,
It was proposed by the board when he went in for a review in 2003. An initial question in the minutes, and I have it here somewhere. They asked him, would the owner of lot 43 agree to not subdivide the property anymore, meaning the parent parcel? And of course, he couldn't answer that at the time, and it's in the minutes. He said he would ask. And when they asked him, I think he said he didn't mind, but it wasn't his idea. The board brought it up. I'll find them somewhere.
And this, the last public hearing that we had, there was a gentleman that spoke.
Here it is.
Not in favor of that, that's, I'm pretty sure what's one of the property owners there, piece, right? You know, that
Wanted the original agreement.
wanted the original agreement.
Okay, so I can read this here. Discussion arose whether the road is class 5 or class 6. The fact that Woodhill Hooksett is, let's say, road is considered a dead-end road and that the board has already denied a previous subdivision proposal in this section. That was the 1997. These are dated August 28th of 03. Safety concerns raised and access of emergency vehicles, period. Question asked if owner of lot number 43 would be willing to commit in writing that there would be no further subdivision of remaining parcel. Now there, they didn't even, and sometimes the minutes aren't complete, they didn't even bring up a secondary access. Question asked if Mr. Jolica would be willing to also commit to no further subdivision of the 10-acre parcel should it be subdivided. Mr. Jolica agreed to such restriction and offered to have a deed restriction placed as well as to consider installing a sprinkler system in the home he hopes to build. It's right here, so I can give you these minutes. I have other copies. Would you like these? So it was the board's idea. It was brought up by the chairman.
At that meeting, the board was gonna ask council some important questions. So I think
Well,
what,
that's fine.
so the, lost my train of thought there, but the, the question about the dead, whether or not a class 6 road, a road that's been discontinued, an existing road, a town road of record, that this is considered a dead end road and this 12 lots applies to existing roads, or is it to proposed roads? And I think we demonstrated that it's been interpreted both ways. And it's lots have been subdivided and it was interpreted that it doesn't apply. And then later on, it was interpreted that does apply. And then after that, it was determined it doesn't apply. And then after that, it was the history of the subdivisions on this road alone go both ways over time. So that's a legitimate question is, does it apply or doesn't it? And that's important to us moving forward. With our, even if it becomes a legal issue, as to whether or not this really does. So obviously you can't share with us council's recommendations, but I'm hoping that he gave you some guidance that you could then share with us and about what direction you feel about this ordinance. Does it apply to existing roads or does it only apply to subdivision street? If that would help us a great deal in understanding where to go from here.
So since the last meeting too, and I sent Carrie a bunch of other plans. I actually went on the GIS website and said, okay, so let's look at other places. And there's 2 very large subdivisions in 1979, Rosewood and is it Gormley? They had a lot of lots. There's a single access. And I think you missed these ones. I found another one. 1995. We have a single access right down here, but we've got all these lots. This one 2007. These are new. But there's not just 12 lots on these. I don't know. This one says Peasley.
That one,
There's-
that one has
There's-
divided.
It's a divided entrance going in until the,
Okay,
Is that Hampshire Hills?
and then Hampton
I don't-
Hills is
I
the
don't-
same way.
don't-
Same way, they are.
okay.
It's a divided piece, and then once they get to where the road loops around and comes back.
Yeah,
Same thing with Dicandra Drive.
Yeah.
It's like,
so these are new.
right.
Do it.
But it's meeting, it's
It
meeting
meets-
the access. The divided road going in
Mhm,
is two forms of egress.
okay,
I didn't make the rule, but that's what it is. It's
Okay.
kind of,
It
it
does.
opens up the road wider. Trees come down, something comes down.
Mhm.
Because this road is now really wide because it's divided.
all you can do is your best, right?
Yeah.
Um,
That's why our safety center going in, there's so much. Trees were taken. From the driveway because they wanted two forms of egress for a safety center. So it was widen it out. The gravel's heavy, they'd have to drive on the grass as it was blocking the asphalt, but it's designed to take that.
okay, so with that,
We got that.
well, I mean, if it works, great.
Yeah,
But
I don't know what.
this isn't an option that's available here,
I understand this.
so. Here we are, I,
I get, the piece I'm hung up on is the agreement that was made. Of Not,
Plan
not further subdivided.
Yeah.
Which you agree is a piece to take to the court and for you to fix.
Yeah.
And, I don't want to give an opinion of, what we'd do if that was off there.
understood. You don't want to second guess a prior board. And we understand that. What we're asking you to do is to act on this application subject to that matter being resolved, which is our responsibility. We're not looking to put that on the board, but we would like to hear how you would apply it. Because the court is going to ask me that. Did you go to the board and ask them to fix it? They're going to ask. Oh,
Get a council.
I don't know.
I do have some information from town council.
Okay.
So do we want to go into non-public?
I also have some information for another application, so I don't know if you want to do that all at once in one non-public or how you want to handle it.
We should just. For time, I know we should probably do one at a time, go in and get it. Everything, come back. We'll have to go, we have an available room down here we can go to, or do we gotta kick everybody out?
I hope I can run and make sure we're in the middle of starting construction, but I think we can probably still make.
We
do.
can always go into the select board.
Oh, you're here, yeah.
I'll make a motion that we enter into non-public session
For the purposes of reviewing.
application. Yeah.
Um,
For purposes of reviewing town council for application 501-23. I'm sorry. Yes, 501-23 and 404-23.
If we have a second. Okay, we can do a roll call.
Yes.
Mike,
Aye.
Adam?
Aye.
It's not.
Aye.
Aye.
Sandy, aye.
Sandy, aye. All right. We'll be back shortly.
And then.
Much more enlightened now.
Yeah, I was.
Something like
actually, I
that.
worked in the guys.
Or
Okay, we're gonna wait.
a little poorer after.
Like lost. So I'm gonna bring us back to order. Mike will be with us in a moment. Which this is a public hearing too, and I think before I get too far in with, we're gonna, what's that?
No, I don't need to.
No, we're not, wait, this, Mike. I'm gonna bring it to the public and see what kind of comments we get. Yeah. So if anybody from the public has anything they'd like to add, I just ask that you state your name and address and. Yes, sir.
Richard Thomas, 181 Wood Hill, Hudson. In the meeting that the lawyer was just talking about, the planning board at the time clearly said no. Point out 2 feet does apply. But they felt sorry for this today, and they allowed him to do one lot subdivision. With the vision that he agreed that there'd be no further attempts to divide the property. In a slightly different way than.
Okay, anybody else from the public? Yes, sir.
Daniel Muller from Corner Distance Linsky. I'm here on behalf of Joel Joliker and Marion Bourgeois, who are butters.
Can I just the firm name again? I'm sorry.
Sure, Cronin Distance Linsky. And I'm here on behalf of Mr. Joliker and Marion Bourgeois, who are the owners of 182 Woodhill Road. They are direct butters.
Just for clarification, that lot was part of the original subdivision?
That is part of the 2004 subdivision. So they are subject.
That's the one lot that was,
Yes, so they are subject to the same limitation that has been discussed here. I guess I'm going to try to limit my comments to.
actually, can I ask one more question?
Yes.
And you bought the lot after that, right? When did, or was it, did you own?
He bought in 2004 after the subdivision. Because
Okay.
technically, under the statute, you cannot buy land until there is a subdivision approval.
Yes, okay.
Couple points I want to make. Number one, there's been a lot of talk about the 2004 approval and whether the board had the authority to impose that condition. I guess from my perspective, the time to challenge that decision has long since passed. There are cases such as Town of Auburn versus McAvoy, which basically stands for proposition. If you don't appeal within the time period set by statute for 30 days, and this includes constitutional challenges as well, they're waived. It's done. It's gone. So any claim now that the planning board shouldn't have done that back in 2004, that issue is dead. It's on the plan, whether it was an express condition or whether somebody said orally, I agreed to do that, makes little difference. There's another case called Siborowski versus the Town of Rye, dating back to the 1970s, which basically says if an applicant makes a representation, they're bound by that representation. So if the board says, will you do this? And they say yes, such is life. There's also a notion here that's been brought up that, you know, essentially we're stuck with this and we shouldn't be stuck with this. It's not really fair. As a matter of law, when they bought the property, there's no question that the subdivision plan with that condition was recorded in the registry of deeds. As a matter of law, you're deemed to have at least constructive notice of it, whether you looked at it or not, and you're sort of stuck. You're presumed to know what the records say in the registry. And if you didn't, it's sort of shame on you. Likewise, you're presumed to know what land use regulations apply to your lot. Here that there is a subdivision approval and that there is perhaps some conditions that you probably should have looked at. So while we hear about this supposed hardship is sort of self-created here. The other issue, and this sort of goes to the more current interpretation. A, there is no reference to existing roads in the regulation at issue. O2P. You can't add that word, which is essentially what the applicant is doing here to make their point. Likewise, this is not what they call a retrospective or retroactive law. That term is a term of art in the law. It talks about laws that impair what they call vested rights, i.e., I already have the right to do this. It's already established. In this case, that'd be a notion that I already have the subdivision approval, and I'm trying to do it. Now you pass something after the fact to say I can't do it. That's not what is occurring here. Just because it has been applied to existing roads does not make it retrospective. It doesn't meet the definition. It doesn't meet any requirement there. So some of these arguments that are being made, some of these legal arguments simply don't apply here. The other thing, I've heard this notion of that it's a covenant and not a condition. It's again, it's on the approved subdivision plan. It is a condition of approval. And that is within this board's general jurisdiction. But as I said, in this case, if there was to be a challenge that had to come back in 2003, 2004, within the 30 days of the approval. So from my perspective, now I'm looking at somebody who has a condition that wasn't challenged and is there. And that's just a fact of the case, and they're stuck with that condition. At least as it is currently set up. I'll reserve comments in terms of the substance. As to whether, in terms of just under general principles of planning law, whether a proposed subdivision that has a quote driveway that cuts through 3 lots is really good planning. This is really proper land for this sort of subdivision, or whether this is indeed scattered premature or inappropriate for building purposes. But I'll say those arguments if you get by that. Thank you.
Anybody else? Yes, sir.
Paul Rifle, 169 Woodhill Exit Road, 31 years. I spoke against this subdivision in 2021 and wanted to comment on the waiver request tonight. Again, the 302E, does it apply to an existing road? I think regardless of which way that decision is made, this language from 302P has been borrowed and put into this deed to this specific lot, and it applies regardless of whether you think it applies to an existing road or not. I think there was a realization that for the purposes of this discussion, Woodhill Exit Road is a dead end. It's got 30+ houses, enough's enough. That's a concern. This deal was made, and that's the way it should stay. There's another waiver request that says because the unmaintained part of Woodhill Exit Road is class 6, then it's technically a through road. When you turn onto my street, there's a yellow sign that says no outlet. And if you try to take a passenger vehicle through the unmaintained part of that road right now, you're not going to gain egress. 4-wheel drive, maybe. There's a comment about undue hardship. I think anybody buying a property and their real estate agent, seeing this language and knowing that you also would be banking on getting a wetlands variance to do a subdivision is short-sighted. And I ask that you deny this subdivision.
Okay. Anybody else?
Can I get the spelling of your last name, please?
RAICHLE.
Not seeing any more. I'm gonna close the meeting, close the public hearing. Close the meeting, yeah.
Go
Um. So, and here, what our attorney had said with this, in our discussion with that. The issue is. The language in the deed. As far as,
Condition of approval.
what's that? For the
Conditional.
the conditional approval, as far as the 12 lot piece. I don't think that we should even address that yet. I mean, it's not really, we're not addressing that. The piece is what's in this deed. And, it was put in. The ever lot that was subdivided off this. That's part of why they bought this too. So it's, you're creating a hardship to that lot. When, I know if, I have a public well behind me, if that land, was, I don't think I'll ever have a neighbor there. If something was to change, you buy your lot knowing what you have there. When you buy a budding conservation land, so he bought knowing that there's only gonna be one more lot next to him, and it's not gonna get any closer. It's part of my thought with it, but I think that it is the notes that's on the plan and what was agreed upon, is why the board can't approve this.
The only time, we've spoken about how long ago it was, the only time that seems to matter is the time that they had to appeal it. Doesn't matter if it was 80 years ago or 20 years ago or 2 years ago, it's outside of appeal.
It is.
Yeah.
I understand what you're saying. I'd point out a couple of corrections to some of the comments that were made. So what started this whole thing was that we didn't catch that note on the plan. Nobody found it. Found this piece of property. It was for sale. And I immediately said, well, we need to get a clarification as to whether or not this 12 lots on Denver Street applies to this or not before you do anything else. We met with the town planner at the time and we were told that it does not apply. And that made us proceed with subdivision plans and an application on the grounds that wasn't. As we got into the subdivision, we discovered this note and we started working on the project beyond that, because we didn't even, I told them, I said, if the town's position is that this is a dead end road and maximum of 12 lots, then the land's not subdividable. We were told it doesn't apply because it's an existing road record, and that's what got us started. Then we got into it and found this note on the plan. So a little different than how it was described. So then, and the other thing with Mr. Joliker, Mr. Joliker was the applicant in the subdivision. He subdivided the lot for himself. He had an agreement to purchase it before that condition was put on, which is just a little bit different than the way that you did it.
Which
it doesn't change the fact that notes on the plan, which
still that was done, and that was, his understanding with the subdivision. And I mean, right, I mean, that's the impression that I got is.
well.
And
you know, you said you bought-
and agreed to it then, and now seems to like it.
Well, that's okay, but which came first? He didn't approach Mr. Day to buy the land, assuming that all the other land around him wouldn't be developed.
What came, there, I think that's irrelevant.
It is relevant because he didn't rely on a restriction being in place for the subdivision or to buy the lot. So to your analogy about if I buy a piece of land and there's a well behind me, I know it's there, I'm stuck with it,
When I bought
whatever the case.
when I bought my land, the well wasn't there.
Oh,
When it went in, I was really happy.
okay, well, if you see something there, when you buy your property, you are stuck with it. It wasn't there when he approached Mr. Day. That restriction was not being applied.
Well, actually, which I heard, and I mean, we don't have this, but that restriction was waived to make a second lot to do a subdivision. right?
No, only
I
his,
just heard some testimony here that,
just his,
that,
just his.
that this was brought up, you know, and they allowed that one more lot subdivision.
He had already committed and approached Mr.
So-
Day to do that, though.
Yeah.
So he didn't buy it because it was gonna be a restriction or a protection for him. That's,
That's what's there now, and
mhm.
the piece that, and I'm pretty sure the board's gonna agree with me here, but we can go around, is that that's what's in there, that's the key
Mhm.
here. You know, would we, you know, and as far as if that didn't apply, you know, if that wasn't in the deed, you know, would we hear it and, you know, and consider it then? We would consider it, but I don't, you know, we're not gonna give our opinion now of we would approve it or wouldn't approve it. The problem, you know, why I don't think it should be approved is the note in the deed saying that it can't be further subdivided.
Okay, and to be clear, the note is not in my client's deed. It's on the,
On
it's on the plan. Okay, I just want to make sure the record's accurate.
The deed does say, oh, I don't know the exact wording.
It refers to the plan.
And it's all restrictions as referenced on the plan.
Yep.
It is tied to the deed, right?
Mhm. Yep.
I'm not a lawyer, I sell truck parts.
Okay,
But just trying to do my best here of, you know, what works for the town, what was there, what the town put in place, and I really don't feel that we should change that decision that was put in there, has been in there since, that was what, 2002, 2004? You know, for 19 years.
Good.
You know, for us to,
I see how quick you got that math.
I sell stuff, I'm pretty good with numbers. I don't know if anybody else has anything they want to add or agree or disagree that, you know, where we're at with this.
Yeah, I mean, yeah, I think the point is that I don't think, I'm not predisposed to, going forward, with the idea that the condition will be removed. If the condition is removed, I think it would be the time to take it up here, but I don't think that I would not vote to review the plan or consider any approval with a condition on the existing plan.
would the board prefer the application be withdrawn and have us go to court to try to extinguish that note on the plan and then return?
That would be fine.
Yes.
That would be more palatable.
Yeah, if that, then we would be able to discuss everything else, and you make a lot of valid points
Okay, so
on,
I mean, 6 one half dozen the other. It's a matter of, is it worth it to invest in that? Because the court is going to want to know, well, what does the town think? And we've got different I mean,
right now, the board's
Is it-
concern is the note on the plan.
okay,
And that the land is restricted from being subdivided because of the 2004.
And you missed the 30-day appeal.
Yeah, and appeal, you know, that's what went in, that's what's recorded, that's our problem, that's
okay,
our issue.
okay, so we should,
If you think that's the best for
I
your
guess.
approach, okay.
well, we're gonna have
I
to.
guess, yeah, without prejudice, just,
Yeah, without prejudice. I mean, we can certainly give it a try. We were hoping to have at least something to offer court as to the interpretation of that provision. Does it apply to an existing town road or does it not? And that's what we were looking for. Because it is ambiguous. There's no question about it.
I think we could beat this horse,
Mhm.
until
Okay.
it falls over, but.
Yep.
So we, at this
We're not
time,
gonna
I
do
think
that.
I'd like to,
Mhm.
withdraw the application without prejudice and move forward with alternatives and see if we can't get this straightened out.
Try.
Really thank all you guys for your time.
Okay.
That's one question. Are you withdrawing the CUP and the subdivision?
Yes,
Mhm.
yeah,
Okay,
thank you.
Thank you.
for bringing it to a head. Okay.
Okay.
Yeah.
Raise representative.
He's, yeah, okay. Okay, that was exciting.
Like every time we say it. wrong, it's not as long as-
You have a,
And then when we say it's gonna be short, we're like, it's like 9:45. This is like, now this one could take forever too.
This is a new person that.
This is just the first hearing that, so.
So it's always nice to know. How long you.
Yeah, because we don't have a plan, or we have.
Yeah, watch me at work.
Direct. Yeah. It's not better than planning.
I'd like to make a copy of this.
Sure, I say leave that for me, so. Okay, all right, moving on. So let's get rid of this too. All right, application 205-23, Tyler Builders,
Sorry,
502. I gotta stop bringing my glasses.
you gotta borrow that.
Holy cow. All right, application 502-23, Tyler Builders, Inc., continued from 615 major subdivision for a 5-lot residential subdivision located at Brown Hill Road, map 8, block 4, lot 123 in the rural zone. And it looks like we're gonna be at the same time talking about application 406-23 Tyler Buildings, Inc., 615 for wetland protection conditional use permit for 2,200 square feet of wetland impact and 25,000 square feet of buffer impact for the construction of a road to a 5-lot subdivision and to construct 2 stormwater detention basins located at Brown Hill Road, map 8, lot 4, lot 123 in the Arden zone. All right.
Hi.
Hey, well, new engineer.
I'm Craig Francisco with Bedford Design. Al Buteau, builders, you know that, Santiago, how are you? Property is located on Brown Hill Road. Buena Vista Drive is right opposite this. This property, this whole thing was subdivided in 73. Yes, we're gonna have another history lesson. We like history. These 4 lots were created, sold, built upon. This strip of land was left back piece. The Richard D plan had a 60-foot dimension. Triangular flares for the roadway. So in my opinion, it's very obvious this is going to be a roadway. Deeds to these butters, it mentions this road. I'm not going to get into all the detail, but it does mention this. So we're proposing, the land basically slopes down, wetland in green here, kind of bisects the property. And it slopes back up. The top of the hill is about 50 feet higher than the wetland. This, we have 5 lots. One here, 3, 4, and 5. We couldn't quite get enough 2 acres contiguous buildable to get a 6th lot. The issue we have is sight distance coming out of the road.
Okay,
Eric Mitchell was here, I believe, in August last year, maybe sometime last summer he was here. The same property. And described the whole thing. He
talk about.
So actually, the way it works, you have a 3 foot, you have a car sitting 14.5 feet, might be 13.5, don't quote me on the distance. Back from the edge of pavement. And the eyeball is 3 foot 9 inches high. Which would be here. So you need 400 feet of sight distance. We would have, except line of sight goes across these lots, and there's trees and things in the way, which I didn't show on here on purpose, but there are trees that set are in here, so we do not have 400 feet of sight distance. We probably have more like 200. However, over here, I'm showing Ashto's safe stopping sight distance. So you're driving down this road, somebody pulls out at this grade at the speed limit of 30 miles an hour. You can stop before you hit this guy. You have enough time, you have enough room. Same way coming the other direction. So we meet Ashto's safe stopping sight distance. We do not meet intersection sight distance. And there's nothing we can do about it. We've got, except, well, yeah, we cut down a whole bunch of trees for neighbors. That ain't gonna happen, I don't think.
Did you talk to neighbors?
No.
No.
No, not yet. I did talk to one of you.
Okay, well, anyways,
Yeah, well,
public.
it doesn't matter. We were doing test bits, I was talking to somebody. Anyway. So what I would really, I mean, I know there's things we have to do in this plan. There's other things that need fixed besides the site distance. I've talked to Conservation Monday. There's several things they want about the conditional use permit. I mean, there's, you changed my road regulation on me in the middle, and I missed that. I submitted like 2 days before the planning board meeting where you approved the road redesign with the curbing, so forth. So I know I gotta fix all that, but I don't want to spend Al's money if I don't get the site distance waiver. So I'm here to hopefully get a site walk so you can look at this thing and talk about the waiver.
Okay.
I mean, I'll talk about the whole thing, but I'm.
No, you might as well talk the first time. And
Right.
I mean, sight distance is pretty important. I mean, obviously, before we have a sidewalk, we have to accept it and we have, it's us in pretty far, but I know I'm gonna be very concerned about sight distance. It's, I mean, that's,
I understand.
Yeah, that road is a little hairy already. But I think
Brown Hill, so is this a flat area, Brown Hill, or it's all,
Dude, this
it's
is coming
downhill?
down, and it's the people coming down that seem to go pretty fast there, so. That would be a problem with sidewalk, but.
Yeah.
to-
Yeah, really, we should change the speed limits to like 45, which would increase the sight distance to 600 or 800. But with 30 mile an hour, right, what is that, a 30 or 35? 30 mile an hour road, that's why it's only it shortens the sight distance. Higher the speed limit, the bigger the sight distance.
True.
People don't drive the speed limit.
I was,
So,
in the previous meeting, I watched, Mr. Mitchell was here. The board and people said, yes, they do in this area, because it's so up and down and twist and curvy, they travel over 30 miles. That's it on the record from a year ago.
But they had it at 35.
Yes, Eric had it at 35. You guys all correct them, said it was 30. And I don't remember who the board member was anymore that said that people don't drive that fast here.
I mean, it is a curvy hill.
Yeah.
You have to accept jurisdiction
You have
before opening a public one.
Yeah. So, and so that's the question, I mean, as far as the board is, to accept this, so that's what we have to do before we can really get into it any deeper. And I mean, and really, start spending more of the applicant's money.
Probably gonna meet the site. You do a site, you can't do a site walk without accepting it.
Usually don't. I don't know if they say.
think that would help.
Yeah, I think would help a lot if you saw.
Yeah.
Sidewalk definitely would help.
Yeah, it would. I mean,
Yeah.
that's my big concern is.
I don't want to dot all my i's and T, cross all the T's, so you guys can accept it. It's not else money for,
Mm,
to get an acceptance, so we can just go to
Right.
this place, we can go look at it. Anytime.
Yeah, so I think it's a good
I mean-
approach to focus on the site distance because that's kind of if you don't have that, you don't have anything else. So it's a good turning point. I will say there are a few other pretty significant concerns. One relating to, if you create a road where it's just a strip of land right now, it creates right of way, which creates, another frontage for the abutting lots and they do not meet the setbacks.
The 50 feet isn't really enough, well, it's enough to put the road.
But the right of way,
Takes From the
right?
right of way.
So if it creates a right of way, so it creates a second front setback on the side of what's currently the side of those abutting lots,
And what's the side setback now?
30. No, so currently it's 20, but this becomes a front, then it's a 35.
So it comes 15 more feet.
Right. So we'd have to find some way to address that.
Okay. I mean, and I get, we really supposed to accept it before we open the public. I got a pretty good feeling we have neighbors here.
Yeah.
I mean. And if we accept it and don't like the site distance, it's,
Then you can deny the waiver if you don't feel if it's
Yep.
justified, so.
as far as do they have everything in? If,
Yeah, just looking at, so.
complete enough to accept.
So Matt's opinion was that it could be considered substantially complete if the setbacks were addressed. The road width is addressed and there's a few checklist items, which
We're
would
waiting to
become.
the CUP, the wetland CUP, I think. Or beyond that all. I know there were some wetland CUPs.
Yeah.
And we could accept just a subdivision, just for 50223.
Good.
That'll get us a site walk, that'll get us public hearing.
I would say, it's hard,
Obviously, I'm gonna do much else tonight besides,
except here, yeah, I think
Yeah.
hearing from the public and scheduling a site walk, I think is exactly what you want to do tonight.
I'll make a motion. For completeness of application and acceptance of jurisdiction for. Application. 502-23.
A second.
all those in favor? Aye. Opposed? All right. We got jurisdiction now. Go to the sidewalk first, that's first,
Sure, that's a great idea.
you know, there,
The next
when's our next meeting?
17. Right, August 17th.
Then look at my calendar.
Imagine August being
Do what?
a little ugly in terms of.
Oh,
And I will be here.
So are we intending to only look at site distance or? The
Well, we're not, I mean, I think that's the first step, because if we don't like site distance and, you know, then we're not getting into the CUP, we're not doing, I mean, because to look at the wetlands and stuff, it's gonna take a lot more work on this gentleman's part, but I mean, so basically we'd be looking at doing a
I mean,
second site walk to see wetland and,
it's really not that far down the wetland. You know, something.
I mean, I that's up to the applicant, really. I mean, I think what's,
I think we'd be silly not to walk down the wetland while we're there.
Mhm.
Like I said, it's only 500 feet away.
Mhm.
Road's been flagged.
It's all flagged. The wetlands all flagged.
You're gonna do it.
Oh,
tonight,
so
right?
yeah,
Yeah, it's already.
it's
6
already.
o'clock.
If you guys are available.
Yeah, no, that's-
Yeah.
Yeah, well, I guess we need more time.
5:30?
We'll run up there.
Had it once and not doing it.
Um,
How far in is it from the road?
500-600 feet. I won't make that.
That's pretty much all.
It's pretty open. It's not thick woods or anything you're walking through.
Let him know.
I will not.
There, that's where all this.
Oh, you won't either?
What's that? I will not. I'm going in for a little surgery that day.
Oh, okay. Well, let's have that off then. Okay. We need to schedule the meeting or?
Sounds like. So you're not here?
I can't make it, no.
Same here.
Oh, wow. All right, summer's tough.
I mean, we thought that we could actually, I mean, do we have other stuff on that schedule yet?
Just got one today, two today.
24.
I'm good for the 24th.
Well, that would be after the planning board meeting. Are you talking about July?
No.
August.
August 24th.
Right.
See you later, not.
Moving the planning board.
Moving the
moving
planning board
planning
meeting.
and the. site.
We're kind of off their thing right now and just working on our schedule.
I could do the 24th.
So adjust the planning board meeting and the sidewalk
Okay.
for both that evening?
Yeah.
Is that gonna give us enough time? 5:30, that's.
And
Yeah, I mean, I guess it's an hour out there.
All right.
right,
Did you make a
but
motion on that? Or is that?
Oh, yeah, we probably do need
Need a
to.
change to your schedule.
the other thing is that, you know, the Conservation Commission doesn't get to meet after they did the site walk.
Can we,
Which they haven't been to conservation yet, right? Obviously, this is.
Well,
This is
he
your
did
first step.
present, but the
Okay.
fact is that
when is
still need
when
to-
is the conservation meeting?
it's the Monday before so it's
So
the
the
14th,
14th.
right?
Can we do a site walk on a Saturday? The 12th?
We've done that before.
Do the sidewalk on the 12th. That gives the opportunity for Conservation Commission to have their meeting on the 14th, and then we would have the planning board meeting on the 24th.
I can make that work.
Yeah, we need to do it early, though.
No,
We're
that'd be
ready for
good.
3 meetings a week or 2 meetings a week.
It's like 8 AM.
Sure.
Karen, could you just like send the email reminders?
Sure, we'll be all over that.
Okay.
So let me just recap. So Tyler Builders site walk Saturday, August 12th at 8 AM. And then the August planning board meeting will move to August 24th at 7 o'clock normal.
Correct.
Correct.
So someone want to
You need to make a motion with a
to amend the meeting schedule.
I'll make a motion to amend the meeting schedule for the planning board session from August 17th to August 24th.
Second.
all those in favor?
Aye.
All right.
Back to the topic.
Now we're back to the applicant.
Topic at hand. I will note that the Tim Sweeney, the Public Works Director, has already given his opinion that he does not recommend granting the waiver for site distance. I can ask if he's available to join you at your site walk, if that's helpful.
Yes.
Saturday morning for.
Tim's like willing to do anything. He always says. If he can't make it, he can't make it, but I'll ask if he can.
Okay. So with that, this is a public hearing. We have, looks like eager people waiting to talk to us. So I will open the public hearing. Anybody has anything that? Yes, just state your name and address, please.
Edward Duke, 50 Brown Hill Road. That's the butter.
Last name, please.
Duke, DUKE. My wife's got most of the stuff. We're gonna go over here, but. What I'd like to ask is you guys talk to Bo PD before you do your sidewalk. About speeders on the road. It's a good idea. They had a speed trap up there the last month. Well,
Oh, the tracker.
the tracker, they had a speed tracker up there the last like 2 or 3
Yeah, they're a little-
days, tracking all the speeds of everyone on the road. And last fall, they gave out several citations on the road for speeders. So they may have some good input.
Which road is that?
Thank you.
I mean, if we can get some. If they've had their little trailer out there,
I can ask if they can share that data.
Hearsay.
see if they can throw it back out there again.
Jessica Duke, 50 Brown Hill Road. I was the one who contacted the police to put that tracker out there because I saw in the one of the letters or applications to get the waiver, it said that people don't tend to speed on this road, and I just wanted to prove with our data that yes, they do. So I contacted the police to put that up. So it's been up for about a month. They just took it down today to get the data. I was hoping to get it in time for this meeting, but
Okay, so it's been up recent.
yeah, it's been up for the last month. They just took it down today. So hopefully we'll get that back soon. I do have a question. I'm a little confused at what the public hearing right now is on. Is it just for the site distance waiver or is it for?
No, it's for the project. Anything that you've got to, right now is your time to give us opinion.
I'm trying to shine.
This will not be the only public hearing.
Okay,
Other chance.
okay. Well, then I guess I'll start.
Actually, before you start though, this as we're,
Yeah,
but this was the only time your notice you got about the meeting will be your only notice. So pay attention to schedule and
oh,
we're on it.
I'm sure.
So-
I am all over it. The last Brian Westover, who used to be in the office, he used to automatically just email me and say, nothing's been submitted, nothing's been submitted, because they got to the point where I'd email him on the day, and be like, has it been submitted yet?
There
So
you go.
I'm on it. I'm gonna start with safety concerns. We have two young daughters, 5 and 2, or almost 2. And this is our house right here. This is our, well, what we thought was our lawn, which we found out is in the right of way, which we didn't know when we purchased it. So a road cutting through our groomed backyard with 2 small children is a big concern for us. There's a lot
So
of,
you mow in,
yeah, oh yeah, you can
Yeah.
see it here. And this also goes over our driveway turnaround.
Paved driveway.
Paved driveway. So a little background, when we purchased our lot, Mr. Robinson, Robert's son, sorry, who owned this lot, also owned all this. So he sold our lot and this lot at the same time. So for the last 30 years, this was all his. So he really blurred that line because it was his property.
you guys put the driveway in or what you
Oh,
bought?
it was in there when we bought the house. And when we bought the house, we knew that this plot of land was also for sale and we had concerns about that. And he told us that he has owned this land for 30 plus years. He never wanted to see a subdivision be built. He always wanted this just to be land. And he was not going to accept any offer if it was going to be a subdivision. So to our surprise, we find out, and I don't know what happened behind closed doors. It's not like I have anything in writing. That's just what we were told when we bought the house from our real estate agent and his real estate agent. So I think you mentioned earlier, when you buy a house, you buy it with the expectation of what this is. And our thought was worst case scenario would probably happen would be a driveway and a nice house. That's what we thought. We didn't think this would ever become a town road that basically is gonna be a couple feet from our garage. This is our well. So that's a whole other section that I've got on here to talk about well distances, because you know it should be 75 feet from any roadway, and it's clearly not going to.
75 feet from Brown Hill?
No, maybe, I don't know, but it's a lot further away than it is from this proposed. And I know Brown Hill in the past has had issues with salt and contaminating people's wells, so that's clearly a concern. And where you see that this is going to be like the entrance pad. So they're going to be spending a lot of time, especially in the beginning, really close to our well. So you're looking at soil compaction, and it's just creates a lot of concern and worry for us for our well.
When was your house built? You know?
1976. It was after, so.
Okay. 70s.
Yeah, do I have this paper? So this was the subdivision that was approved in 1973, that created our lot and then created that giant lot. So that's near around that.
From the original subdivision.
Yes, and then our house was built afterwards. So safety. So as you can see how close our yard will be, there's nothing on the plans currently for any guardrails or anything here. So if someone's coming down Brown Hill in the winter and there's ice and they want to turn on this proposed, there's nothing really preventing them from sliding off that road and essentially into our house, our property. So that creates a big safety concern for us, especially with our driveway being so close. This is where our girls ride our bike. It's where they play the chalk. We're out there a lot. So safety is our number one concern for our girls and our dogs, obviously our girls. Like I mentioned, we did contact OPD to put that speed tracker up so that we could have hard data. So it just wasn't an emotional or opinion, it was hard facts. So when I get that data, I'll definitely share it with you guys. I talked about the pollution that we're worried about with storm water runoff from the road. It also talks about fertilization and how for erosion control, you have to fertilize and then put like erosion control. And with the fertilization being so close to our well too, we just have concerns on how that would impact it. I'm not sure if it would.
You fertilize your lawn?
No. All natural. Project our well, home and driveway. Yeah, so as Carrie said, it puts, now we don't have the appropriate setbacks.
Yeah, now
We really off now. So that's a concern. Gosh, I feel like I had too much. Oh, a buffer strip. So I think it's never written down. Well, it's note 14, but I don't have the exact 302C, that at least a 50-foot buffer strip should go along property lines and especially on either side of a road. And you could clearly see there's buffer strips put in everywhere else.
on
But
the wall, it's another road.
Well, yeah, but it's correct.
Yeah.
Yeah. And just curious as to why there's not a buffer strip from the road. I think there should be, based on regulations. Maybe I'm interpreting them different, but.
But typically the roads in center of the subdivision, and the subdivision external has the perimeter buffer that goes around it.
But the road wouldn't.
Yeah,
Okay.
it's just, this is the roads coming after
Got it.
rather than before.
Yeah, so. I feel like I could. Say a lot more, but I know we're up at almost that time. We have a lot of concerns, so.
Duly noted. I get, like I said, this.
Yeah.
As this goes on, before things, if it moves further, there will be
Yeah,
more time and we'll get into road and wetland and, that's all stuff that will be addressed at public meetings.
yeah, and it was March 3rd of last year at the last meeting, and the planning board did ask for the applicant or the developer to talk to the abutters. We've never been approached, so that's a little discerning that we're not part of this conversation when this is clearly going to impact our house and where we live. So thank you for your time.
Thank you.
I'm not gonna add too much more because a lot of her people are our concerns. My name's Jean Cooper and I live at 52 Brown Hill Road. And I think you'll understand better when you do the site walk to see that where they're proposing to put in the road, it pretty much comes right into our front yard. And there's not a lot of space between our driveway and where that road would be. And all the headlights come right into our living room. It's very close to the door, same concerns that cars lose control for whatever reason. And next thing you know, it's in our front door or in one of the 2 bedrooms. The other concern is is that we all work from home, or the majority of us, a lot of us work from home. And the amount of disruption it would cause, I mean, I am on my phone 8 to 5, Monday through Friday, to have all of this machinery come through and take down all of the trees. They'd also be taking down part of our stone wall and trees to open up that road. And I have concerns about the impact to our leach field. I don't know how they would remove the trees. I don't know any of the logistics part of it, But I have concerns that that machinery could damage our leach field as well. And then the only other thing is, I do worry about our wildlife. We see a lot of wildlife in our backyards. This is gonna do nothing more than displace them even more.
Where is your leach field with respect to? Is it on, I'm assuming your house is tilted facing? Let's see, is it in here? Right there.
Oh, yep, this one. So it's right back here. It's right along the tree line right here, actually. So again, I don't know how they're gonna remove all those trees without impacting our leach field.
Well,
And
I
our
mean, I don't
wells
see them
right there.
removing trees on your property.
What?
I don't see them removing trees on your property.
Well, again, you'll see it, you'll know it when you see it. You'll see how it's set up where there's a very thin line of trees that are ours. And then the trees that go between our house and the Duke's house. And it's not a straight line. I think the one thing that we've all come to the conclusion is that when we did, our assessor came out and did it and put in all the stuff, it is not straight. It's a very weird line that goes back there. So again, I don't know the logistics of how they take down those trees, and how it wouldn't impact them either having to take down our trees or impact again our leach field. And also just the overall impact of wells, by putting in 5 more wells, that's just making or impacting the wells that are already out there. I mean, I think it's all had issues, especially.
I mean, one thing that I will add, with this, I understand your concerns. And I do have to say is, people have a right to develop. I hear this, the thing about wells a lot. Well, this is gonna go in, that's not something that the planning board can say, oh, you can't develop the land because there's poor water. That's not gonna happen. Site distance is a big issue. That's because it's a safety piece. Some of the setbacks and where stuff is, that's gonna be a bigger concerns. The wildlife, we care about it, but there's the endangered, that, there's different stuff that does limit it, but the planning board can't deny something because it's gonna get that, this. So.
Sorry, one more thing. Did I say my name again? Jess Duke, 50 Brown Hill Road. Both our driveways too are within 50 feet of the roadway. Does that pertain? Because I know that's like zoning ordinance section 6.06 that it has to be, any driveway has to be 50 feet away from a road, from an away from an entrance to a road, and
Like 10 feet.
yeah, both of our driveways are much closer than 50 feet, so.
I'm concerned with pulling into the driveway thing.
The road, yeah.
Yes.
So I just want to bring that up. It's on the plans, but I just want to bring that to attention. And then I know there's a waiver has been requested for the site distance, which we're talking about. There was also a waiver for a restoration plan. And I'm a little bit, guess I have a couple questions on that. So if the waiver was accepted, would then the applicant not have to give a restoration plan?
Yeah, I mean, that's usually a bond that so they start the project and don't complete it, that there's money to.
Yeah, because that concerns us because,
That would
we
trouble.
called on our house during the building of the road and then all of a sudden the applicant got business, what do we do? So,
That would concern the planning board also.
yeah, so I know that's been a waiver that's been requested as well, so. Well, yeah, that's. Thank you.
Anything else?
I'm good.
All right.
They covered it, yeah. I'll let it rest.
All right, with that, I'm gonna close the meeting. Close the public hearing. So we got a site walk, we're gonna go and look at it, and before we get too deep in everything else, I mean, to the applicant, there's definitely a lot of serious concerns here. At first, the site distance and the corner, gonna say, you wanna talk about the neighbors and see if they'll help you open that up. But that could be tricky. So. Did the applicant have anything else they wanted to add or? We see,
I just wanted to mention, just one quick thing for, Jessica's edification. I think you mentioned you felt a little left out of the process. Okay, I wanted to explain. The applicant actually changed companies helping him to do the work, so there was some disconnect in getting everything transitioned. That's why you haven't heard from anybody. So I'm sure they will be in touch. Okay, didn't mean to leave it out.
and I will say, you know, as I see processes, you know, until it gets here, you know, when they know that, okay, we're gonna really spend some money, they don't talk to neighbors. I mean, I think that's a pretty normal thing. You know, at this point, now they're starting, hopefully they do have, you know, I encourage applicants to, you know, have good dialogue and hopefully everybody can be neighborly and work things out and,
So I did see you.
You did see me, yes.
I did talk to you.
Do we have to do anything else on number 5, or is that we're just assuming we're not touching upon that?
Wondering about timeline. Yeah, so as far as the CUP goes, do you want to accept that now too, so they're running together? Probably easier just to keep them running on the same
Okay.
path.
Okay, I think there are a couple of things that were identified as being missing from it, so.
Okay, let's look at that
I think
then.
it was the actual NH.
I have with me today.
And the,
Have it now.
I guess, so
and the functional
if
assessment.
we accept that now and go, we're gonna open the public hearing one more time.
Or, yeah, let me just look again at that one. So, yeah, you said the things that were missing were the NHB letter, which you have available. Okay, and then the
Functional
ballot. The wetlands functional assessment. Are you able to address that or?
I will gladly address that after I get my site distance waiver.
Right.
Okay. Okay.
So we're gonna wait to,
No, we can, I mean, I guess we could still accept the CUP.
I mean, does the applicant prefer us to accept the CUP tonight?
I would prefer it just so they run together,
Okay.
but it's.
Obviously, we know we're gonna, you know,
Right.
accept it and continue the meeting, so,
Okay.
all right.
All right, I say, I move that we accept wetland protection conditional use permit for Tyler Builders Inc. Application 406.
Second,
All those in favor?
Aye.
Opposed?
that was me.
You have to open a public hearing.
I really do, right?
You did.
All right, well, so since we have accepted the conditional use permit, I'm gonna open it to the public. If anybody has any more they'd like to add,
So specific to the wetlands.
specific to the wetlands, which we are gonna end up continuing this, so we'll be able to.
Jessica Duke, 50 Brown Hill Road. The only thing I will say, because I've said a lot already, is that I would like to see if we can get a definition on whether there's a stream going through that wetland. We have some pictures of our walks through there where basically, it looks like it could be a stream.
In the
So,
last couple of weeks, it was probably a river.
oh, well, yes, last couple of weeks aside. So, and I know if it is a stream, I think that makes the setbacks go up to 75 feet instead of 50 feet, the buffer setbacks. So just taking that into consideration. That's all I'll say.
And I'll assure you that the Sandy and the Conservation Commission will be
That's what I got.
on.
I attended that meeting and that was the tidbit I got.
Okay. The applicant have anything else? So anybody from the public want to talk? I'm gonna close the public hearing on the CUP.
I will add something about the wetlands. This wetlands that crosses through here, there's a high point right here. Yeah, it might be here. This flows this way, this flows this way. Like I told the Conservation Commission, I'm shocked that this is wet. And the saddle little wetland, but it is wetlands. I don't believe it's a stream. We'll go out and look at it. There's no water there in March when I was there. I think it was March. You may know better now. There was some snow in the ground. But there was no water here.
So where are that's the high point, so both sides go down?
Yeah, this goes both directions. It's very strange. And it's wet. I can't believe it's wet on top of the saddle. If you look at the old plan from Mr. Mitchell, the wetland stopped here and stopped here. Tom Sofkolowski flagged them for us. I don't remember when, I believe last July or August, something like that. He flagged the wetlands and he went out this spring and did test pits in the soils. So. But take a look. I think you have somebody on your board who can tell us if it's a stream. For sure.
I do have some correspondence from the town's attorney in relation to this application. I don't know if you want to review it tonight or save it for next meeting. It's not going to affect anything you do tonight, obviously, because you're not making any final decisions.
Want to save it? Or you wanna-
Jim for later.
Yeah, we'd have to.
Excited.
Happy
for August 24th all month.
Fresh. Anyway. I'm gonna keep you in suspense.
Wait, I have a question. Are we allowed to join the sidewalk?
Yeah, absolutely.
Okay.
Yeah, so then 8 AM,
8 AM, August 12th.
August 12th, there'll be the sidewalk, yeah, at the public, it is so at a sidewalk, it is a public meeting. We don't take any comments. It is a time where you can ask questions to the applicant. But we don't take minutes at them, so
We do minutes.
we do minutes, but we don't
discuss.
discuss, we don't get into.
Got it, understood.
So questions that you ask there, you're gonna reiterate back at the meeting. All right. Applicant, we're good. I think we need a motion to continue these.
I move that we continue applications 502-23 and 406-23 to our next meeting on August 24th.
If
August 24th.
second.
All those in favor? All right, opposed? All right. We will see you on the 14th and again on the 24th,
Well,
August 12th, I'm sorry.
As I say, I wrote down the 12th. Don't confuse me.
12th.
Don't confuse me.
Natalie
I'm
Moore.
gonna take my easel back. I'll be here Monday.
We wait for it.
I'll take my easel back. Don't worry about this.
so you're to accept. Yeah. Noted, we got it. Thanks. Awesome.
Okay.
Yeah, great job, guys.
Minutes.
Yep.
And then as far as correspondence, there's just a notice from the town of Bosquen. I'm sure you remember when Bell Tower was in front of this board, they had to notify all the towns within 20 miles.
Right.
Got a notification of one, so I just information.
Only 120 feet.
Andrew, you got my comments on these?
Speaking of cell towers?
Yes,
Word.
I got it again.
no updates.
No update.
And there's no construction because
They can't start anything.
Nothing can happen until it's
How long do those appeals usually take?
a long time.
I live on that side. The cell service is great.
I get that.
So anyways. We get some minutes? One second. June 15th.
general rule, they seem much tighter than they were a year ago. Minutes.
They've just been working really hard on it.
Is it- They're much more succinct. Good.
She's been working really hard.
Congratulations. It's a real improvement.
I do have a few little.
No, go ahead.
Okay, just, the first one is more of a style thing, because I think it's different how we usually do it on line 43. Motion by Kip and seconded by me. Says it was resolved to approve. Are we using that language, or that's kind of
You're saying the resolved or the
the
approved?
resolved?
Yeah,
I think we
Is-
usually said motion made to approve. Do we usually, I mean,
What do you say? It
Yeah. A motion was made to approve.
just take out it was resolved and then just leave it as to approve. Um,
I think. Sorry, not to dig into this further, but I think instead of upon motion made, it should say a motion was.
Right.
made.
yes, yeah.
We've been using that right along.
Yeah, it's-
Change that on everything then?
Well, when you say everything. Let's try, it's a style thing, like you said, so it's. For the future.
Right, because if you say a motion was made, then it's that resolve doesn't
Yeah,
fit. So if we take out resolve, you need to change it to a motion was made. I think down below on 87, where it says their traffic engineer and this. I would say, Flatleys or something, because the whole previous two sentences talk about NHDOT, so.
It's traffic engineer.
Right, or the Flatley company, I don't know how we wanna,
Yeah, John Bentley Company.
yeah. I think 142, 143, there was. There was like a sentence missing.
It's a line break. Yeah.
Oh, simply, okay, good, that's good, yep, that's it.
I have a question. Would you like to be referred to as Selectman Wayne or Mr. Wayne? The honorable.
What for chair?
I know.
Yeah.
Selectmen, I guess, but I'm getting the big bucks for it.
Yeah.
More than we get.
It's not enough, Sam.
Yeah, no, I'm
Not
sure,
enough.
I'm sure, I'm sure.
I didn't sign up to make money.
Yeah.
Okay, is that it?
I think if you're gonna carry that same thing,
Oh.
you can just go through, because there's multiple.
The
motions
upon,
made, upon
right,
motion
yep,
made, So
yep.
it's 200, 215,
223.
223,
Yeah.
32.
Oh, it was yours, I'll look at that.
Well, wait a minute, so, okay, just at every vote.
Yeah.
I would,
Yeah.
yeah, just to
I,
search.
yeah,
for page.
actually. The one place I looked and it didn't have the result, so I. thought,
Yeah, all those are. And same on 238, 241.
That means both. It's like the way in this thing.
Yeah, I had both. That's why I wanted to ask. Some people care about those things, so that's why I ask.
It's something that I don't care about.
I didn't think, but.
Just don't call you late for dinner, all right?
Yeah.
All right. You good on motions?
Motion to approve minutes as amended.
Second.
All those in favor?
Aye.
Opposed?
I was not here, so I'm gonna abstain.
You want to make the motion?
No, listen, somebody else. I don't make motions.
Come on. Motion to adjourn.
Hey, I'll second.
All those in favor?
Aye.
Hi,
All right.
yeah.
Good work.
We're gonna be here late.
That went quicker than I thought it would. Well, I'll give you a buzz.
Okay, fine. I can write my.
Cut out.
Well, I got it right here.
Oh, good, okay. Is that the 4962738?
I'm gonna probably need another one of those because Mike's stealing it.
4962738.
Good.